At a compliance and election hearing, theoretically the judge is supposed to determine whether or not the prosecutor has met their obligation to turn over any evidence that's required of them and to let the defendant decide whether or not to go to trial or whether or not to plead guilty. Sometimes you can elect whether you want a jury trial or a bench trial if you're fighting the case. But in practice, these are more often like another pretrial date. They often get multiple C&E dates, compliance and election dates, whatever you call them. It's not usually much different than a pretrial date, because often it takes a while for the prosecutor to turn over evidence that they're required to do. Sometimes we're getting other evidence ourselves. We're conducting our own investigation and we want some more time. Sometimes we're going to issue a subpoena to a third party. So a lot of times it doesn't make sense to have just a pretrial, just a compliance date, and then trial. Cases spread out for various reasons. Sometimes a compliance date might be combined with a motion hearing. So you might actually have a motion to dismiss hearing that also acts as a compliance date. Sometimes you file a motion to dismiss or a motion to suppress at the compliance date, and then you get a date for hearing on those motions. Sometimes you have gotten evidence from the prosecutor and you're asking for more evidence based on your review of what's already been turned over. So a compliance date doesn't mean you're about to go to trial necessarily. Depending on the facts, it can just be like another pretrial date. If you don't know what's going to happen, talk to your attorney. Ask the attorney what the plan is at the compliance date. The attorney will explain to you what to expect and then what the next date is likely going to be.